You're listening to the Immigration Lawyers Toolbox podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Thank you for joining us for episode number 436 of the Immigration Lawyers Toolbox podcast. This is a special one. I've been wanting to do it for like years. It's on my to-do list. But to have a special episode that's like the top memos that immigration lawyers should know. And, they kind of, they're all over the place. There's like so many memos. And I was like, I narrowed down to family-based, which I labeled it here. But it's not purely family-based, you'll see. But it's the ones, if you're doing family-based, it's good because I thought I'd make a separate one for employment-based and other kind of issues. But these three memos I'm going to go over so important that practitioners read and know really well. And we're going to go over in detail. Heads up that I think one of them, the main one, the top one, for free, we have a CLE. It's an hour going through it on the Immigration Lawyers Toolbox private community page. It's available for any U.S. attorney to watch. It's free. Great CLE episode. It's mandatory. Obviously, everyone has to watch that to be a good immigration attorney. And they have to go through that PDF, which is 50 pages. I'm ruining the surprise. But anyways, I'll talk about it in a second. So just want to heads up. It's really fun. I want to do more of these. I thought I'd get this out and try to do employment-based and just different aspects of immigration practice that you should know about. I do want to thank the sponsor, too, of this Immigration Lawyers Toolbox episode, eimmigration by Cerenade. Y'all know that already. Case management software does really well and really helps you take things to the next level. And something special we've been doing for the last couple of months is doing webinar seminars to make you just more calm and resilient in your practice as we're going through so much. And on December 4th, Wednesday at 10 a.m. Pacific, they're doing a webinar called Keys to Building Resilience in Immigration Law for 2026 with an all-star panel going over important subjects that you should be aware of to be able to develop your practice, your management, your cases, and to really take things again to the next level and just shoot for the moon and the stars in the coming year 2026. So I want to thank them for that. The registration link for that will be in the show notes below. And also I want to tell you, if you like how I'm presenting stuff here, I'm not sure how smooth I am in this presentation because I was in a rush doing it, so I should say that. But our consular processing course, we have a marriage green card course that goes over the whole family immigration process. I'm updating the consular processing version. I'm going to do a live session. It's a premium course, but it's discounted for the live session on how to do consular processing. So important for every immigration lawyer to know, anyone who's coming in, and in those who are doing it, see how I'm doing it. We're going to go through our contract looks, things we worry about, experience, all that kind of stuff. And it's heavily discounted compared to the whole course if you want to buy the whole thing. But this is consular processing section without affidavit support is there. It's coming up on December 18th at 10 a.m. Pacific. It's going to be around 2 hours. If you need more time, we'll add some there. I'm doing an addendum. But I definitely recommend doing it. With a lot of people in the past, I really enjoyed, learned a lot. And it's been about 2 years since I've done a live course. Actually, we did the E2 courses, EB1A and E2 courses live in 2020 this year. So, but doing a family-based course, consular processing stuff. So get this in. I'm not going to do another consular processing live. Probably do like I-130, FA support, inadmissibility hour, this and that on these courses, but not going to get back to live consular processing. Definitely recommend you check this out. I think it's going to better your practice and make you a better immigration lawyer. Having said all that, none of the information provided here is intended as individual legal guidance. Please consult an immigration attorney about your case. But y'all know that already. Let's get the show started. Having a good recollection of the memos USCIS has for both like bringing it up to the clients and to the government when needed is of utmost importance. And just being prepared ahead of time for strategizing is so important. That's why these three memos right here are essential for immigration lawyers. Everyone has to know them, but especially if you're doing family-based cases, right at the top when you're doing a consultation, you have to be aware of these issues that come up in these cases. And the top three are regarding I-751, adjustment of status, and inadmissibility. And these are three, again, you have to be prepared for ahead of time because they come up all the time. And I found that a lot of attorneys, frankly, don't know these memos or how they apply. So I want to make sure I share it with you. So let's start. I'll share my screen. The first memo I want to reference is the I-751 memo from 2009 when there's a divorce that happens, I-751 filed prior to termination of marriage. And so we have these situations sometimes where someone gets a conditional green card and the relationship starts to fall apart. And by the time of I-751 filing, the distressful part will be they're separated, but they're not divorced yet. And USCIS is taking the position that they can't approve the I-751 until the divorce is finalized. So it gets pretty tricky. And that's why when people contact us and they're like, my relationship's not too good with my spouse, but I might be able to hang in there. I'm like, don't do that, because I-751s could take 2, 3, 4 years to be approved. And that time you're inevitably going to get a divorce. And if you stay in a bad relationship, by the time the interview happens, a bad spouse might be like, I'm not going to go to the interview. And then you're really out of luck with creating problems. And also, like getting the divorce done as soon as possible is probably better, because the states like in California, it could take 6 months for at least for a divorce to be finalized. Now, I haven't done this, but some lawyers have said you could stipulate that the divorce happens sooner, but then like at 6 month mark, where it's required, that's when you could discuss like possession of goods and property, that kind of stuff in custody. But it varies and depends on state and family law. So I don't want to get into that here. But that's the case. What we do most of the time is the person comes to us, say, okay, immediately file the divorce, and we'll file the I-751 either jointly with the spouse if they're there, or separately, and have a memo in there that says they're going to update the record of the divorce certificate. And 10 out of 10 times when the clients file pro se divorces, they have errors which take longer to get. So hopefully they hire a divorce attorney. But it really comes in here, like on the bottom, I think it was page 2 of it. If a service center ISO encounters an I-751 petition jointly filed by co-petitioners who are still married but are legally separated and or are in pending divorce annulment proceedings, the ISO issues the conditional permanent resident a request for evidence with an 87-day response period. That's why you want to get that in, because if divorce takes longer, you're going to miss that period. But what we've done in the past, when they haven't had a divorce in time, we let them know with the divorce filing that we need more time to either issue another RFE or ask for an in-person interview, and we'll have the divorce record ready by then. Here it says in the RFE, the ISO specifically asked the CPR, conditional permanent resident, to provide a copy of the final divorce decree or annulment, along with the request stating that he or she would like to have a joint filing petition treated as a waiver. And that becomes really important right there. Is attorneys sometimes submit a new I-751, sometimes even with fee, to change it from a jointly filed I-751 to a waiver-based one. But you don't need to do that. Essentially, you just need to make a request to have it changed from a joint filing petition to be treated as a waiver petition, and that's in this memo. This affords the CPR an opportunity to provide evidence that the proceedings have been finalized, and it affords the CPR an opportunity to request a waiver of the joint filing without refiling. So it specifically says you don't need refiling in these kind of situations. You don't want to get caught up in that. If the CPR provides evidence that the proceedings have been finalized, the ISO amends the I-751 to indicate that CPR is eligible for a waiver, yada, yada, yada. And then based on the either, approve it or schedule an interview. In doing so, the ISO determines whether sufficient evidence, yada, yada, yada. They might even do an in-person interview with them. Now, we've had it where we notified the government of this, that they're getting divorced, and it's not even finalized, and they've approved the I-751, which is kind of annoying, because you're like, well, you don't have the final divorce certificate. Is that going to be a problem as citizenship? So in those kind of cases, we've mailed the divorce certificate saying, listen, we got the I-751 approved. Feel free to reopen it, but here's the divorce certificate. We want to be on record, so there's no problems. In those cases there's 2 of them in particular we've had that the citizenship case was approved too, but we have it all on the record, so it doesn't look like we're trying to hide something or it's problematic. Or we had it where people file for divorce, and like we're going to update the government, but like a week later, the I-751 was approved. So we immediately contact the government and say, listen, we initiated divorce proceedings, divorce is happening, just so you know that we weren't trying to hide this. So just the timing happened like the way it did. So if you want to reopen it, they did it, and we've had citizenship approved. But these are the kind of like timeline things. And this I-751 waiver, when there's, relationships aren't going well, it's probably the worst time part of the immigration process. It gets so tricky unnecessarily. Just I-751 in general is such an unnecessary process. The ombudsman's office did a report back when, like 2 years ago, and they realized like the amount of fraud that happens that it gets caught in the I-751 is so minuscule that it makes the whole process really not worth it. But it's a politically charged one that if you say you're taking it away, it's going to, rile up a lot of people. But that's and there's more info right there. You should definitely read it. Read it. It's not the best written memo, so it's only 3 pages, but you got to read it frequently and a couple times to really get it. So that's the first memo. The second, hey everybody, I'm going to jump in really quick to remind you of our live consular processing course for lawyers coming up December 18th at 10 a.m. Pacific. Join, be there, or be square. We're going to teach you how to do immigration law on the consular level. So much to know there, whether you're new to it, never done it before, or you've done a lot of them. Really get to be able to share experiences, see what I'm doing, and I, give copies of my contract, the places there's fees that come in, my experience I learned the hard way, blood, sweat, and tears, and issues, and losses we've had. Not a case loss, but it's like when I'm working on a case, I forgot to include a fee for this section because now it's costing extra more. How I could place the contract, a lot of that stuff, and just a lot of how to do it, be efficient with National Visa Center, registering. There's just so many million nuances when it comes to consular processing that you need to know that I really recommend joining this course. and being there. If you want to register, email me at info@immigrationlawyerstoolbox.com and I'll send you a registration link, and also have in the show notes so you can see it there. But get there quick before it fills up. Usually I like to limit these courses to like 5 people max, just to keep it into like a private environment where we can talk more fluently instead of having more people in that. So I recommend joining as soon as possible. And again, the registration link is going to be in the show notes, but you can always email me, info@immigrationlawyerstoolbox.com. Let's get back to the show. The one that's up most important is the adjustment of status memo, particularly related to the visa waiver program. This was issued in November 14, 2013. Quick note, the I-751 memo, they've updated just last week. I'm recording this in October 2025. The USCIS policy manual to reflect a lot of that memo, so you get a lot of information there too with more details. But with regard to this visa waiver program adjustment, a lot of lawyers don't know you can file for adjustment of status on the visa waiver program if you're an immediate relative case. So that's if your spouse of U.S. citizen, parent of U.S. citizen, or minor child of U.S. citizen. The exception of it, the problem with it is that when you sign up for the visa waiver program and you enter U.S. ESTA, you give away the right to have a removal hearing, immigration court hearing, unless you're going to file for asylum in immigration court. Other than that, you can't get immigration court hearing. And that, so this really outlines that so people know. And what's going to happen is inevitably your 90 days is going to run out and the adjustment's going to be pending, so it'll be out of status. Historically, it was an issue in a Trump administration. Sometimes they'll pick you up. And so it's really risky to file for adjustment of status in the visa waiver program because you don't get that backup. But an exception, again, a lot of people aren't aware of, is that in the Ninth Circuit, there was a lawsuit, and it's in the footnotes here, that in the Ninth Circuit, if you filed the case within 90 days of entry, then you are able to get removal hearings. Now, the way it's worded, let me pause it to find the exact wording that's troublesome potentially, or maybe I don't want to share because DHS might be listening. So let me pause it. Okay, I'm back. So the memo says that a VWP visa waiver program overstay whose case is denied by USCIS has no appeal rights and may not be placed in removal proceedings before an immigration judge. There is, however, an exception for cases filed within the jurisdiction of the Ninth Circuit. A visa waiver program overstay who is an immediate relative and whose Form I-45 was filed within 90 days of period of admission within the jurisdiction of Ninth Circuit is entitled to be placed in removal proceedings under INA Section 240 should the adjustment application be denied by USCIS. So there's 2 points there. One is that you got to file within 90 days. And people are always afraid of this immigrant intent rule of 90-day filing and stuff like that. But people come and after a month or two realize they want to stay. So that immigrant intent historically has been a problem. Who knows under Trump how annoying they're going to be about it. But there's other part that says that's if the application is denied by USCIS. In such cases, USCIS will refer the case to ICE for its consideration. USCIS may also issue an NTA before referring a Ninth Circuit case to ICE, and doing so is consistent with USCIS guidance on NTA issuance. So that sounds cool. You get the opportunity if your I-485 is denied to have a second hearing in court, which is great. And we always use that if there's Ninth Circuit and the client, changes their intent after entry. But nowadays, with the Trump administration just picking people up or out of status, you may not be able to get it because this memo and it says that if the USCIS, if the case is denied, but what if they, their visa waiver overstay with an I-485 pending? Then they get picked up. The case has not been adjudicated yet, so they might be able to they might be deported, removed based on being an ESTA entry, VWP, and the USCIS case is still pending, so it's not denied, so they don't get it entitled to it. So that's one of those things you probably want to file a lawsuit, habeas corpus kind of case, and then appeal it, and it's gonna be a big Ninth Circuit thing because the language. No one would have thought ICE would have picked people up in these kind of situations unless they've been arrest history or something like that, or criminal history. So that's something that might be problematic. You have to jump and do lawsuits on. In the footnote number 13, it cites the court cases in the Ninth Circuit that allow immediate relatives to do it, but not like preference cases. But it gets kind of troublesome. But it's very important to know that these are possible. And so I've had people come to me and said, "A lawyer said you can't adjust on a BWP," but it is possible. But there's risks involved. Now, quick note is my associate and I did a review of other circuit court cases. And it was kind of vague and like open-ended as to they would allow this whole 90-day thing. So if you're in another circuit and you file for it within 90 days and there's problems and stuff, you could potentially file a lawsuit and move it up the circuits on appeal to get them. And they say accept the Ninth Circuit because there are 2 or 3 circuits that were kind of open to this idea, but they didn't have a ruling in place, or district court cases. So potentially you get this expanded to beyond just the Ninth Circuit. And so the Ninth Circuit, that you got to shoehorn yourself in there, the camel's nose under the tent, potentially this could be expanded. But at the very least, it's very important to know this memo and read it. Again, November 14, 2023, Policy Manual PM, Policy Memorandum 6020093. I'll put links to it somehow in the show notes so you have it. And the final and most important that every immigration should know, it's not even family-based, but I just reference that because it's so important, is a consolidation of guidance concerning unlawful presence for purposes of Section 212A. Now, this is so important. It's 51 pages. I've had to read this multiple times, probably 10 or 15 times in my life. And on the Immigration Lawyers Toolbox community page, I have an hour CLE going over the 3 or 10-year bar portion of it. It's just so important for you. Have to know this. This is really, really important. It's free CLE. So if you're an immigration lawyer, if you're a lawyer in general, you can join our community page. Just go to immigrationlawyerstoolbox.com, click on the community tab, and they'll give you a registration page so that we could get your bar info, make sure you're a lawyer, and add you there. But it goes over how the 3 or 10-year bar apply. And importantly, what is unlawful presence as opposed to violating status? How does it work with DS, duration of status, unlawful presence? What if you have extension of status or change of status pending? Is that unlawful presence accumulation? It's really, really important to know and be educate. Now, this memo is kind of old. There are issues with it, like it's saying that if you have extension of status, the pause unlawful presence accumulation ends at like 180 days or something like that. But that doesn't apply. It's continuous. The duration of status situation may be changing pretty soon in the Trump administration, where new F1 students and J1 students will lose duration of status, which prevents you from accumulating lawful presence days unless there's a finding of being out of status by the government or something like that. But older cases will still have this old rule. And it looks like it's not going to apply to old F1s. But so important to know this memo. You go through in detail. It's just too long to go over here. But I want to share with you, we have a breakdown that's really good. Like if you have asylum pending, that pauses unlawful presence accumulation, but doesn't mean it's status. So you got to differentiate what these are. And like if you're on asylum and you work without authorization, that accounts as unlawful presence days. And so if you leave the U.S. And want to come back in, you could be affected by a 3 or 10-year bar for working without authorization. With asylum pending, you should definitely get your EAD. And all these different situations on B1s and B2s, and like there's so much information on how this tolling system works and what unlawful presence is. They're a complex subject, and it has samples that you could do. There's one of them right here that goes into INA 245K, which is, I don't think it's correct the way it does the thing, but read it for yourselves. Can't remember what it was. There was one fact pattern that I think was incorrect that they have here, but how parole works. But there's so much knowledge of immigration in this. Every immigration has to read this and know it really well. So if you need to read it 4 or 5 times, do it. It's going to up you to the next level of game as an immigration lawyer. I'll have this in show notes, but it's the unlawful presence memo from, let's see, 2009. Extremely, extremely important. No. Thank you everyone for joining. We have content just like this on our private page. So videos that we don't put in public for lawyers. So it's more detailed. We don't have to give disclaimers. Join our community page for U.S. lawyers. Just we need bar info. Go to immigrationlawyerstoolbox.com and click on the community tab and follow us on Instagram. When we post these kind of things, you get notified of it. Instagram is Immigration Lawyers Toolbox. If you go to immigrationlawyerstoolbox.com, at the bottom we'll have a link to our social media where we publish a ton of content, samples of different things that could help you, even on the public pages, statistics on what's going on in visa issuances, and a lot more. Thank you so much for listening. Like and subscribe wherever you're watching this. Until next one, have a good one. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.